Hi, I'm Attorney Dragana Knezic, and I work in the Criminal and Traffic Division here at Constantakis Law Office. Today, I want to talk about OWIs, operating while intoxicated charges, and help break down what they really mean. Now, before we get into the details, let's clear up a common question. What's the difference between an OWI and a DUI? The answer is basically not much. There's very similar, but here in Wisconsin, the official term for drunk driving is OWI. So that's the term we'll be using throughout this video. What is an OWI? You can be charged with an OWI if you're caught driving with a blood alcohol concentration, or BAC, over the legal limit of 0.08%, assuming it's your first offense. But it's not just about alcohol. OWI charges also apply if you're under the influence of other substances, like marijuana, controlled drugs, or even certain prescription medications that can impair your ability to drive safely. It's also important to note that the rules are even stricter for commercial drivers. For them, the legal BAC limit is just 0.04. Now that we've gone over the basics, let's talk about some common misconceptions people have when it comes to OWI charges. What are some common misconceptions about OWIs? One of the biggest misconceptions about drunk driving charges is that it's easier to just pay the fine and move on. But the truth is, there are a lot of hidden consequences that people often don't think about. For example, while the initial ticket for a first offense usually runs between $700 and $1,000, that's just the beginning. You'll likely be required to complete an AODA assessment. That's alcohol and other drug abuse, which can add a few hundred to another $1,000 in costs. Another thing to keep in mind, while a first OWI offense isn't considered a criminal charge here in Wisconsin, that's not the case in many other states. So if you're applying for a job out of state, potential employers might see that OWI on your record and treat it as a criminal conviction. Another common myth is that refusing a breathalyzer test means you can't be charged. That's simply not true. Refusing can actually be used as evidence against you, and it often leads law enforcement to get a warrant for a blood test, which can still confirm whether you were impaired. And finally, many people believe that if you blow below the legal limit of 0.08, you're in the clear. But that's not always the case. If officers determine that you're impaired and unable to safely operate a vehicle, even with a BAC under 0.08, you can still be charged with an OWI. Now that we've cleared up some of these common misconceptions, let's move on to the actual consequences you could face with an OWI charge. OWI first. In Wisconsin, a first-time OWI is classified as a civil offense, not a criminal one. But that doesn't mean it's just a slap on the wrist. There are still serious consequences that can follow you for a long time. For starters, you'll face fines and mandatory courses that can easily total over $1,000. And that's just the beginning. Once you have an OWI on your record, your car insurance rates will skyrocket, sometimes up to 3 times your normal premium, because you'll now be considered a high-risk driver. There are also certain factors that can make things worse. For example, if there was a minor in the car at the time of the offense, the charge automatically becomes criminal, even if it's your first OWI. OWI second. A second OWI comes with much more serious consequences than a first. Not only are the fines higher, but a second offense is now considered a criminal charge. There's also mandatory jail time, anywhere from 5 days to 6 months. On top of that, your driver's license will be revoked for at least 12 months, and possibly up to 18 months. You'll also be required to install an IID. That's an ignition interlock device in your vehicle, which prevents the car from starting until you pass a breath test. These consequences don't just affect your personal life. They can impact your job, especially when it comes to the time spent in jail or having a criminal conviction on your record. OWI third. No matter how much time has passed between convictions, a third OWI comes with automatic and serious consequences. If you're convicted a third time, you're looking at mandatory jail time, anywhere from 45 days to a full year. The fines also go up significantly, ranging from $2,500 to as much as $8,000 if there are aggravating factors. Your driver's license will be revoked for 2 to 3 years, and once you're eligible to drive again, you'll be required to have an IID, ignition interlock device, installed for up to 3 years. Another major change, your legal BAC limit for any future tests will be permanently lowered to just 0.08. That's a big shift and something that can impact you for the rest of your life. OWI fourth and higher. A fourth OWI, and any after that, are considered felonies in Wisconsin, and the consequences are even more severe. You could face up to 6 years in jail and fines that can total up to $10,000. Your driver's license will also be revoked for up to 3 years, and if your last OWI was within the past 15 years, you won't even be eligible for an occupational license during that time. And it only gets tougher from there. With each additional conviction beyond the fourth, the penalties continue to increase. Longer jail times, higher fines, and less flexibility from the courts. I hope this video was informational for you. If you have any further questions, feel free to check out our website for more in-depth information on each specific conviction, or give us a call at 414-427-6181.